can lie any way he wants and get a warrant. Anybody can do it. Rule 42 is criminal contempt. This is something to eschew. Rule 43 is Glendora is always present. She doesn't like to miss a thing. The $5,000 bond was totally unnecessary. Glendora has never missed a deadline for a legal paper nor a court appearance and is in the courthouse and the clerk's office and watching other judges a dozen times in between. She doesn't want to miss anything. You know, I think that's kind of funny, you know, when you stop and think about it. Back on March 6, 1997, Thursday, here they were making me sign a $5,000 bond that I would come back to court. And at the same time, Ramos is asking the judge to exclude Glendora from the court. Now, that's kind of funny. You know, even after your rights have been denied all day and you've been brutalized by the police state, you can still laugh about that. $5,000 bond to make sure that I come back to court, but at the same time, Ramos is saying to the judge, don't let Glendora into any more district courts. Rule 44 is right to an assignment of counsel. Glendora thanks the court, but it is settled. She will be her principal attorney. She will be pro se. She has the concern for the taxpayers. Rule 45, time. Computation. In computing any period of time, the day of the act or event from which the designated period of time begins to run shall not be included. The last day of the period so computed shall be included unless it is a Saturday, a Sunday, or a legal holiday, or when the act to be done is the filing of some paper in court. A day on which weather or other conditions have made the office of the clerk of the district court inaccessible. And you know, folks, this nearly happened. On March the 31st, 1997, Monday at 10 a.m., when the winds were 60 miles per hour in Brooklyn, and when there were drenching rains and even sleet. But we made it. As did Brian Sussman, and as did Harvey Cash. Thank you. Thank you. Again, Glendora has never missed her deadline and never intends to, and never has asked for an enlargement. Rule 46 is released from custody, and Glendora is thankful she has been, but at the violation of her civil rights, and ever aware nobody ever had probable cause to put her in custody, which she terms captivity. They call it custody, but it's captivity. Glendora should be exonerated. She will never miss a court date. She never has, just as she has never missed a Sunday in church. Rule 47 is nice. Motions. An application to the court for an order shall be by motion. A motion other than one made during a trial or hearing shall be in writing unless the court permits it to be made orally. It shall state the grounds upon which it is made and shall set forth the relief or order sought. It may be supported by an affidavit. Don't worry about that word motion. That's just if you want something from the court. That's how you ask for it, a motion. As soon as she finishes this memorandum of law in the Federal Rules of Criminal Procedure, Glendora will make a breezy motion, a big motion, excuse me. Oh, strike that. A big, B-E-E-E-G, motion. Glendora stayed up Thursday night to write a motion to dismiss, and Friday morning in court, it worked. It stopped everything. This is in another case and in another court. Rule 48, dismissal. The Attorney General of the United States Attorney may, by leave of court, file a dismissal of an indictment, information, or complaint, and the prosecution shall thereupon terminate. Go ahead and do that, Ramos. You owe it to America. If there is unnecessary delay in presenting the charge to a grand jury, that's out, or in filing an information against the defendant, that's out, it's been filed, who's been held to answer to the district court, or if there is unnecessary delay in bringing a defendant to trial. Now, we got a chance there, folks. The court may dismiss the information. Hope still looms in the human chest. Rule 49. Service and filing of papers. Service shall be made upon the attorney. Unless service upon the party personally is ordered by the court, service upon the attorney or upon a party shall be made in the manner provided in civil actions. That's a snap. You and I have read the Federal Rules of Civil Procedure twice. Now we've read the Federal Rules of Criminal Procedure twice. Notice of orders. and filing, and Glendora says we can do this in our sleep. We are in the clerk's office more than we are in the dining room. Glendora has read the Federal Rules of Criminal Procedure twice, Rule 1 to Federal Rules of Civil Procedure twice, Rule 1 to Rule 86, and she has read the Federal Rules of Criminal Procedure twice, Rule 1 to Rule 60. Rule 60. Rule 50. Calendars planned for prompt disposition. The district courts may provide for placing criminal proceedings upon appropriate calendars. Plan for achieving prompt disposition of criminal cases. To minimize undue delay and to further the prompt disposition of criminal cases, each district court shall conduct a continuing study of the administration of criminal justice in the district court and before United States magistrate judges of the district. And Glendora learned about this on the something, and she ruminates about stopping the clock April 7th to April 28th. That's 3 weeks they stopped the clock. The jury is still out on that one. There are just 10 more rules to go. We have to stop and go to Merrill Folsom's memorial service at church. He died at 94 after his 74th wedding anniversary in November. To Eleanor, he was a reporter and bureau chief for the New York Times. April 19, 1997, Saturday at 2 p.m. And here is the memorial service for him. Some of it. We are now on page 26. And this is Rule 51, exceptions are necessary. If a ruling is made and you disagree with that ruling, you don't have to say, I take exception to it. It's good to say it, though, for purposes of appeal. You have to make your objection known, I think, immediately. So I think it's better to be safe than sorry. Don't you? In Rule 52, harmless error and plain error, any error, defect, irregularity, or variance which does not affect substantial rights shall be disregarded. And in its entirety, this action, in its entirety, folks, this whole action is an error. Intentionally. Regulation of conduct in the courtroom, the taking of photographs in the courtroom during the progress of judicial proceedings or radio broadcasting of judicial proceedings from the courtroom shall not be permitted by the court. Well, Glendora says this is very sad. This is America. The public has a First Amendment right to know. Court TV is changing this gradually, and the Federal Judicial Council is reasonable and flexible. May 1st of 1997, Glendora's birthday, the Federal Judicial Council of the United States is considering Glendora's petition to allow audio tape recorders in the courthouse. Rule 54, application and exception. These rules apply to all criminal proceedings in the United States District Courts. You have to be very careful to raise your objections and defenses before you're not able to. In other words, they will consider them waived. Federal magistrate judge means a United States magistrate judge is defined in Article 28 U.S. Code 631, a judge of the United States or another judge or a judicial officer specifically empowered by statute in force in any territory. Law includes statutes and judicial decisions. Proceedings before the United States magistrate judges, proceedings involving misdemeanors and other petty offenses are governed by Rule 58. An act of Congress includes any act of Congress locally applicable to and in force in the District of Columbia. Attorney for the government means the Attorney General, an authorized assistant of the Attorney General, a United States Attorney, an authorized assistant. Magistrate judge includes a United States magistrate judge as defined in Article 28 U.S. Code 631. Rule 55, records. The clerk of the district court and each United States magistrate judge shall keep records in criminal proceedings in such form as the director of the administrative office in the United States courts. That's Ralph Meekum. Glendora watches the record assiduously. Rule 56, courts and clerks. The district court shall be deemed always open. That's something for you to learn, Kenneth H. Mildworm. Rule 56, Federal Rules of Criminal Procedure. And it's Rule 77, Federal Rules of Civil Procedure. You got to learn that, Kenneth H. Mildworm. That the district court shall be deemed always open for the purpose of filing any proper paper, of issuing and returning process, and of making motions and orders. The clerk's office with a clerk or a deputy intendant shall be open during business hours on all days except Saturdays, Sundays, and legal holidays, but a court may provide by local rule or order that its clerk office should be open for specified hours on Saturdays. Well, they should be, and on particular holidays. So this is the rule that you forgot, Kenneth H. Mildworm, when you went berserk. Teach this to the Pinkertons at the Uniondale Brood House. Rule 57, rules by the district courts. In general, each district court, acting by a majority of its district judges, may, after giving appropriate public notice and an opportunity to comment, make and amend rules governing its practice. I would like to know, and I've got to ask the clerk, if there were any new rules in the Eastern District in 1997, and also I've got to ask Joseph Cloyt in the Southern District if there were any new rules there in 1997. And moving on here to page 30, folks. Procedure: when there is no controlling law, a judge may regulate practice in any manner consistent with federal law, these rules, and local rules of the district. Effective date and notice: a local rule so adopted shall take effect upon the date specified by the district court. Now here comes good old Rule 58, Federal Rules of Criminal Procedure. Procedures for misdemeanors and other petty offenses. In general, this rule governs the procedure and practice for the conduct of proceedings involving misdemeanors and other petty offenses. This lie that we assaulted Mildworm, when Mildworm is the one who assaulted us, completely upside down, wrong side out, is a misdemeanor. The trial of a misdemeanor may proceed on an information or complaint, or in the case of a petty offense. No, we don't need that because this isn't a petty offense. At initial appearance, at the defendant's initial appearance on a misdemeanor or other petty offense charge, the court shall inform the defendant of A, the charge, and the maximum possible penalty provided by law. Nobody told us that. The right to retain counsel, unless the charge is a petty offense for which appointment of counsel is not required, the right to request the assignment of counsel, the right to remain silent, the right to trial, judgment, and sentencing before a judge of the district court. That's an Article III judge. There was a most wonderful editorial in the New York Times. That tenure is for good behavior, it's not for life. Tenure is for good behavior, it's not for life. If the defendant is held in custody and charged with a misdemeanor, the right to a preliminary examination, consent and arraignment, trial before a United States magistrate judge. If the defendant signs a written consent to be tried before the magistrate judge, which specifically waives trial before a judge of the district court, the magistrate shall take the defendant's plea. Well, the magistrate took my plea without written consent, that I would stay with the magistrate instead of going to an Article III judge. If the defendant does not consent to trial before the magistrate judge, the defendant shall be ordered to appear before a judge of the district court for further proceedings on notice. Well, Glendora is inclined to keep her magistrate judge. She likes her magistrate. A brief survey of Cadman Plaza East is in the magistrate's favor as being fair and no nonsense. I took a survey, you know. Glendora trusts her magistrate and believes she would do what is right for her country and for God. Glendora wants to know what others think, including the magistrate. Article III judges are deep in white powder. An Article III judge might immediately see this action for what it is, a hoax, and get rid of it fast. If the EDNY, the Eastern District of New York, is like the Southern District of New York, Article III judges do not have tape recorders and depend on court stenographers, and Glendora cannot afford the same. Indeed, 1/3 of the reason that Glendora is in former paupers is because of court stenographers. It's a terrible ripoff. Senate is covered up by judges. Magistrates have tape recorders, and Glendora can eke out the $15 for a dub now and then. What does everybody else think? Remember, we are all called for one purpose: ascertain the truth shall make ye free. And who is my Article 3 judge? I don't even know. New trial, appeal, decision, order, judgment, or sentence by a district judge, decision, order, judgment, or sentence by a United States magistrate judge, interlocutory appeal. Now, we got to watch this one carefully. 10 days. A decision or order by a magistrate judge, which if made by a judge of the district court could be appealed by the government or defendant under any provision of law, shall be subject to an appeal to a judge of the district court, provided such appeal is taken within 10 days of the entry of the decision or order. An appeal should be taken by filing with the clerk of a court. We have the same rule in the civil rules. An appeal should be taken by filing with a court of the clerk a statement specifying the decision or order from which an appeal is taken, and by serving a copy of the statement upon the adverse party personally or by mail, and by filing a copy with a magistrate judge. Got to watch that 10 days. I have 10 days to appeal a decision of the magistrate to the U.S. District Court. Rule 59 effective date happened when Glendora was senior class president, Classical High School, Springfield, Massachusetts. These rules took were made effective on the date 1945 in September. And that's when Glendora was a senior class president, Classical High School, Springfield, Massachusetts, and Franklin had returned from D-Day to VE Day, Normandy to Weimar, and started as a freshman at Boston University to be a newspaper reporter for 37 years. Title. This is the last rule, folks. Rule 60. These rules may be known and cited as the Federal Rules of Criminal Procedure. This rule is similar to Rule 85 of the Federal Rules of Civil Procedure, which reads as follows: these rules may be known and cited as the Federal Rules of Civil Procedure. To which Glendora says, this is profoundly reasonable. What happens when you cross a TV set with a microwave oven? You get to watch 60 minutes in a quarter of an hour. Consummato est. Dated White Plains, New York, April 19, 1997, Saturday, 7:01 p.m. Yours in truth, Glendora. Chat with Glendora, Box 416, White Plains, New York, $7.41, 19 and a half hours. Under penalty of perjury, Glendora served this upon Remus. And that's all of that paper. I must report to you that I was able to read these 3 volumes of Bruiser Ken, Bruiser Kenneth H. Mildworm, Pinkerton at the United States Brood House in Uniondale. I was able to read all 3 volumes of these, 1,020 pages. I filed them, I paginated them, and I read them. Then I finished writing the Federal Rules of Criminal Procedure, which you and I just finished reading, and then I started on a notice of motion and motion by Glendora to dismiss this action. The notice of motion is, the return date is May 5th. It's before U.S. Magistrate Judge Joan M. Azraq. The place is the courtroom, 333, I believe, 225 Cadman Plaza East, Brooklyn, New York. Under penalty of perjury, Glendora declares she's telling you the truth, the whole truth, and nothing but the truth. So help her God. So help all of us, God. Sua sponte, Glendora makes this motion to dismiss this action on the grounds of no probable cause. What the Pinkertons, the U.S. Marshal Service, the Federal Bureau of Investigation, Marshal Service, the Federal Bureau of Investigation, and the U.S. Attorney said happened simply did not happen. It is a lie and a frame-up. There is and there never will be probable cause for this Pinkerton police brutality, for this false arrest and ambush, for illegally detaining Glendora March 6, 1997, 10 a to 6 p, for this malicious prosecution, and for cover-up by these 4 government agencies who have betrayed their country, and for this atrocious taxpayer waste your money. Next page is Glendora tells you, Honorable Joan M. Azraq, what really happened. The incident of February the 18th, 1997, 9:25 a.m. to 9:40 a.m. The complaint is a lie. The misdemeanor information is a lie. And these 4 poseur groups must be prosecuted for cheating the United States of America. Now, this is the incident. And this you know very well. This was read to you right after it happened, in Glendora's complaint, her civil complaint, suing Kenneth Mildworm for $23 million. And so that takes care of page 3. Page 4, page 5, page 6, page 7, all of which you have read and know. Page 8 and 9. Oh, let's look at the bruise again. Let's look at Bruiser Ken's Bruce, one of them. Great guy, isn't he? Great guy. That's just one of them, folks. Remember all the other ones that you saw on videotape? Page 9. Page 10. Page 11. And you have read that. And page 12 and page 13. And page 16 you've read. And the synopsis you've read. Now we're up to page 17. Kenneth H. Mildworm beat up a 68-year-old woman and a 78-year-old man because they asked for a receipt. He took the tape recorder and we asked for a receipt for it so we could retrieve it when we came out of the clerk's office. When Glendora sued Mr. Mildworm and Particeps Criminis, accomplices in crime, for $23 million, the same trumped up a false criminal action to cover up their guilt and colluded with their buddies, the U.S. Marshal Service, the FBI, and the U.S. Attorney, to abuse their people-given authority to retaliate and cover up in disgraceful traitorship to the United States of America. Glendora asked one of the security guards who works at Cablevision Hicksville, where she edits A Chat with Glendora for TV, to be our witness on March the 6th, 1997, Thursday at 10 a.m. when the FBI deceived us into thinking this is bad faith. We're going to help us get justice as to Mr. Mildworm and accomplices, but when the FBI ambushed us and double-crossed us, our witness was locked out. The witness told Glendora he went to the Pinkertons in the lobby of the Uniondale Brood House and inquired. They all sat around with smirks on their faces, reveling in their criminal lies and cover-up and retaliation and traitorship to their country. That this atrocity of malicious and criminal prosecution of lying complaint, false arrest, pernicious detainment, March 6, 1997, all emanated from hearsay in whole or in part is a blot on the escutcheon of the USA. Not in part. That's not in there. I should never have said that. It's in whole. This has to be changed. It was reckless and un-American. Now Glendora refutes the complaint of lies of Kenneth H. Mildworm as signed by the king of hearsay, Thomas Kwiatkowski, March the 5th, 1997. That you have read. That is page 19, page 20, page 21, page 22, page 23, page 24, page 25. Okay. Page 27, retaliation. This action, Mildworm through Ramus, is retaliation, and that is against the law. instead of probable cause, what is before the court is retaliation. Frivolous. This action must be dismissed on the grounds that it is frivolous. Taxpayer waste. The action must be dismissed on the grounds of taxpayer ripoff. I'm looking out for you. And waste of scant judicial resources. Hey, they don't have anything better to do. There's not crime going on. Citizens aren't, there's no crime against the citizens that they should be taking care of. They've got to spend their time doing this. Pernicious cover-up. This action must be dismissed. That it is a pernicious cover-up. Nobody talks about K.H. Mildworm beating up a crime going on. Citizens aren't, there's no crime against the citizens that they should be taking care of. They've got to spend their time doing this. Pernicious cover-up. This action must be dismissed. That it is a pernicious cover-up. Nobody talks about K.H. Mildworm beating up a 68-year-old woman and a 78-year-old man because they asked for a receipt. All the talk is about the false information fraudulently filed by the U.S. Attorney, while the U.S. Attorney has illegally ignored Glendora's request for the immediate arrest of Kenneth H. Mildworm. And the same request to the 1st Precinct, Nassau Police, of February 21st, 1997, Friday, which the FBI took over. Why didn't the FBI take care of that complaint? They took it over from the 1st Precinct, did nothing about it. We're going after that one, folks. Innocence. Glendora is innocent. The burden is on these abusers of due process to prove Glendora is guilty beyond a reasonable doubt, and there is no way in a just court they can do that. Glendora did nothing but stand and wait for clearance to go into the clerk's office and conduct her business pursuant to Federal Rules of Civil Procedure 77. While she was waiting, she was insanely attacked by Kenneth H. Mildworm as the other 6 stood idly by. The misdemeanor information is a false instrument. Here's the misdemeanor information, folks. It's one paragraph. By now, they're beginning to lose confidence in their lies, so they contain it to one paragraph, which is a big lie. Signed by Zachary Carter, and he wasn't even there. What does he know? Let me put this microphone box where it won't clang on the desk. We are up to page 30. Glendora did not assault anyone. She did not assault a federal officer. She did not forcibly assault anyone. She did not forcibly assault a federal officer. She has never assaulted or forcibly assaulted anybody. She is not the assault type. She is against physical assault. If anybody assaults her, she just stands and takes it, as she did the demented and senseless assault February 18, 1997 on her by Kenneth H. Mildworm. Glendora did not knowingly assault anybody February the 18th, forcibly or unforcibly. Glendora did not intentionally or unintentionally assault, unforcibly or forcibly, anyone on February 18th. She never resisted. She voluntarily emptied her pockets of keys, tape recorder, pen, and glasses, placing them in the shabby tray. Then she took her metal name badge off her lapel and placed it in the tray. Her 3-ring binder and legal papers she relinquished to put on the metal detector conveyor belt. She asked for a receipt for her tape recorder. She did not impede the process in any way. She cooperated with it fully. She did not oppose the process in any way, and she did not interfere with the process in any way, not knowingly or unknowingly, not in